Welcome to the Virtual Attorney Bankruptcy Series. I'm James Doan, Senior Partner with the firm. If there's one thing for sure, it's that a well-informed client is a happy client. And we're here to give you some good information as we guide you through each stage of the bankruptcy process. We hope you find this segment particularly interesting and informative.
Everyone who files bankruptcy must attend a meeting of creditors known in bankruptcy circles as a 341A meeting, after the code section where it's found. It's a requirement, but luckily it's not scary. It's not in front of a judge, but with a trustee appointed to your case. The trustee is a court officer, and his or her primary goal is to verify that everything in the bankruptcy filing is true and correct. The trustee also is looking for assets to liquidate to satisfy creditors. You've discussed all of the issues in your bankruptcy with your attorney and thoroughly reviewed your bankruptcy petition, so there should be no surprises. Your hearing date will be held about 30 to 35 days after your petition is filed, and you'll get about 2 to 3 weeks notice. You need to bring a valid driver's license and original Social Security card to the hearing. If you're missing either one of those, your DLF paperwork tells you what other documents the trustee will accept. Plan to arrive 30 minutes early to meet your attorney and go all the way into the courthouse to the designated room. You need extra time to park, get through security, and find the right room. Your attorney will make the process as easy as possible. You'll receive information about who your attorney is and what he or she looks like. The attorney may be waiting inside or outside the room depending on his or her schedule of hearings that day. Once you enter the room, please proceed to the front and pick up a green brochure that contains general bankruptcy information. Please read the brochure while you wait. If you're unsure which brochure to pick up, ask the clerk sitting at the front. Before the session begins, the trustee will introduce him or herself and give general instructions on how to proceed. After the instructions, the trustee will begin calling cases based on the order of the schedule. Each case will take only a few minutes. If you need a translator, you could bring your own, or the court will provide one for most languages. If you bring your own translator, they can't be related to you and must be over 18. Once your name is called, your attorney will come forward and will be right next to you in front of the trustee. The trustee will swear you in and then proceed with questioning. Please be sure you answer questions loudly and clearly, as this is a taped proceeding. Questions will vary from case to case, but some will be similar, sounding something like this. Did you carefully read and review your paperwork before you signed it? Is everything truthful and accurate? Did you list everything you own and everyone you owe money to? Have you filed for bankruptcy before? Creditors are invited to the meeting, but are not required to attend. Any creditors who appear at the hearing may ask you questions about your property and financial affairs under oath. After your hearing is complete, your attorney will give you a copy of your petition or your files, and the trustee will return a copy of your last tax return. If the trustee requires amendments or any other documentation, your attorney will take notes and pass along to the post-petition department, who will work with you to submit the necessary documents. Once the meeting is over, you are free to leave. If you have any additional questions for your attorney, please wait outside until he or she has completed all of the meetings.
There you have it, short, sweet, and to the point. But don't stop now. There's a lot more great information where that came from. Check out our list of videos on our website at doanlawfirm.com. Thanks for stopping by. I hope to see you again soon.